How do vendors legally reduce contract liability risks? Imagine you're running a business and signing contracts with suppliers or service providers. You want to protect yourself from unexpected costs or legal issues. How can vendors do that effectively? Let's explore some proven legal strategies vendors use to keep their risks in check. First, vendors often include a limitation of liability clause in their contracts. This clause sets a maximum amount the vendor might have to pay if something goes wrong. For example, it might say the vendor's total liability cannot exceed the amount paid under the contract. This helps prevent huge financial losses from one claim. Many contracts specify which damages are covered. Vendors usually exclude liability for indirect damages like lost profits or business interruptions unless caused by gross negligence or intentional misconduct. That way, the vendor's responsibility is limited to direct damages only. Exceptions are common too. Vendors might agree that the liability cap does not apply to serious issues like personal injury, fraud, or intellectual property infringement. These are considered too important to limit, so the vendor remains responsible for those types of harm. Vendors also define and limit warranties. They clearly state what they promise about the quality or performance of their goods or services and for how long. If a product fails after the warranty ends, the customer generally cannot claim a breach. This reduces the vendor's ongoing responsibility. Indemnification clauses are another tool. These requiring the vendor to cover certain losses or legal costs if the customer faces claims caused by the vendor's actions. Vendors often negotiate the scope of these clauses to avoid unlimited liability. For example, they might agree to indemnify only for claims resulting from their negligence. Insurance requirements are also key. Contracts may demand that vendors carry specific insurance types like general liability or product liability coverage. If a claim arises, the vendor's insurance policy will pay, not the vendor's own assets. This spreads out the risk and provides financial protection. Confidentiality and intellectual property clauses help too. Vendors include confidentiality agreements to protect sensitive information shared during the contract. They also clarify who owns any new inventions or content created. This reduces disputes over ownership and misuse. Clear termination and dispute resolution clauses are important. They specify how either party can end the contract and how disputes will be handled. Often, disputes are resolved through mediation or arbitration, which can be faster and less costly than court. When creating or reviewing vendor contracts, businesses should be precise and clear. Every key term like scope of work, delivery dates, payment terms, warranties, liability limits, and dispute procedures should be well defined. This makes enforcement easier if issues arise. Regularly reviewing and updating contracts is also wise. Laws change, and business needs evolve. Keeping contracts current ensures they continue to protect the vendor from unnecessary risks. In business law, these strategies are standard for managing risks in commercial deals. They help vendors operate with a predictable level of exposure, which supports stable relationships and reduces costly legal battles. Courts generally uphold these clauses if they are clear and fair, except for liability related to personal injury or fraud, which cannot be waived. To sum up, vendors can legally lower their contract liability risks by carefully drafting key terms, negotiating limits, maintaining proper insurance, and reviewing agreements regularly. These steps help protect their financial health and support long-term success.